2022. We have three hearings today. I'll always remind you guys that we are being recorded and that the chat is only for members. We do have three hearings, two very brief ones and one slightly longer. We have the first one is going to be House Bill 448, it's Delegate Smith, and we have House Bill 388 with Delegate Lukey, and we do have the Attorney General going last. We apologize, sir. I know your time is valuable. However, yours is the longest, so we will get to it very quickly.
We'll make it work. Thank you.
Thank you. Is Delegate Smith here? She may not be, and if she's not, I do believe Delegate Lukey is here, so we will skip on to his. Outstanding. Well, we will be going on to House Bill 388. We'll come back to Delegate Smith's bill shortly. Delegate Lukey.
Thank you very much, and it's very nice to be able to say the words, thank you, Mr. Chairman, and members of the committee. I hope you're all well. House Bill 388 has to do with an issue with which the committee is very familiar, and that's the issue of prevailing wage. As you know, under Maryland law, the vast majority of projects funded by the state government are subject to prevailing wage laws, which were originally designed, frankly, to prevent a race to the bottom in wage payments as companies bid on public contracts. As you know, there's a decades-long record of prevailing wage laws ensuring that Maryland workers get an adequate family-supporting middle-class wage from the work that they do. House Bill 388 simply extends the prevailing wage law to one of the classes of state projects to which it currently does not apply, and that's projects in our higher education institutions. As you may know, for years now, those institutions have been exempt from the same prevailing wage law that applies to all other public works projects. I would argue, frankly, that the workers who build the buildings at our universities deserve the same family supporting middle class wages as workers who work on any other state project. As you'll read in the fiscal note, the University System of Maryland and Morgan State University both say they're already voluntarily complying, so this would essentially codify that current practice, if what they're saying is true, and then it would extend as well to St. Mary's College of Maryland, which is independent from the university system, but still a public college. So I would urge the committee to expand our work to provide those family-supporting middle-class wages to all Maryland workers and to give a favorable report on House Bill 388. Thank you, Mr. Chairman.
Thank you, sir. Are there any questions for the good delegate? Seeing none, we'll move on to the first witness, Roxana Mejia.
Yes, sir. Good afternoon. Good afternoon, Chairman Wilson and members of the Economic Matters Committee. My name is Roxy Mejia. I am a proud member of the International Union of Painters and Allied Trades, and we represent workers in the finishing trades construction industry. Thank you for the opportunity to testify today in support of HB 388. This bill is very important to me and to other women in the construction industry. Prevailing wage helps eliminate the gender gap that exists for women in construction industry. That is because the prevailing wage does not look at a person's gender to determine their wages. Rather, prevailing wage are calculated through impartial surveys and reflect what workers in the area are actually making. This prevents employers from offering women and people of color like me lower wages. Furthermore, this bill encourages local hire and will provide opportunities for many state residents from all walks of life to have careers in the construction industry and to have decent wages for a better quality of life. Applying prevailing wage to the procurement for public work contracts for universities such as Maryland, which is my alma mater, Morgan State, and St. Mary's, will minimize the exploitation of construction workers that look like me, and it will offer opportunities for job trainings. I thank you for your time, and I ask that you vote favorably on HB 388. Thank you.
Thank you very much for your testimony, ma'am. Seeing no questions, we'll go on to our last witness for this bill, Mr. Tom Clark.
Good afternoon, Mr. Chair and members of the committee. My name is Tom Clark. I represent the International Brotherhood of Electrical Workers, Local 26. I encourage the committee to support HB 388 I'd like to begin by defining what prevailing wage is. It's nothing more than the market rate. It's figured out by taking the skill level of a trade or profession and the training involved and the cost of living in that particular area. It's not a high rate, it's just what the market determines. If you're unfamiliar with the term prevailing wage, it's understandable because it's only applied to construction workers. I'm not picking on the university system because the state and the federal government do the same. For example, when the university hires teachers, engineers, janitors, IT personnel, police, social workers, everyone is paid based on the market rate. Sure, both sides might dicker about the price, but at least they start at the market rate. Unfortunately, construction workers live, like the 11,000 members of Local 26, are forced to bargain for wages below the market rate, below what it costs to house, feed, and clothe a family in this area, below the rate that is determined for their knowledge and skill. So I asked the committee that these are the skilled workers, that these are the ones that are paying tuition for their loved ones to attend these institutions. These same highly skilled workers are also the ones that pay the taxes that support these projects that we're discussing. In closing, I just ask, we Marylanders we're just not asking for 1 penny more than what the market demands. So I respectfully ask that you vote favorably on this bill. Thank you.
Thank you, sir. I see one question from Delegate Walker. Delegate Walker.
Okay.
Thank you, Mr. Chair. And I asked this
Wait
question just to
one
get,
second. There you go. Thank you.
got me? I hear all the time about, hey, it's just the local prevailing wage that's in that certain jurisdiction. Well, in my jurisdiction, I'll give you an example and tell me how you feel about it. In my jurisdiction, I'm down in southern Prince George's County, right? So when we had National Harbor was such a project that was so big, they were saying it's almost bigger than just the 26th district or the 27th district. And that's where me and Delegate Valderrama and Delegate Turner represent. And then the wage difference between Prince George's County and Charles County was pretty significant. But yet this is something that's only 3-4 miles away from each other. I mean, what do you feel about that? So I had people telling me, like, if I was a business owner, why wouldn't I set up in Charles County rather than set up in Prince George's County? Well, I know I'm going to have to pay a lot more to set up shop and operate. So just your thoughts on that. I think everybody feels that everybody should have a right to, a wage with decent wages and everything else like that. But when you start talking about, it doesn't really matter, by lines, whether it's, College Park or different areas within the state, we're pretty much set up like we know that there's a huge disparity between different areas, but yet we're so small that there's certain, you go a mile up the road, you're talking about a major influence.
Well, thank you, Delegate. Yeah, and the prevailing wage is based, once again, on the area. So yes, unfortunately, if a project's in Prince George's County, that's what the prevailing wage would be. So it would be a different rate for College Park and the College of Southern Maryland.
Yeah,
and it's part of the prevailing rate, the cost of living.
Not College Park. College Park is going to pay a certain thing. I'm just saying, because we go county by county. If I'm correct, it's a difference between the county and, Prince George's County has a certain rate. And right there, my chairman, his county, they got a lesser rate. So it's kind of like, puts folks in the bind. If I'm trying to draw businesses into my district, into my county, sometimes this could be a hindrance because I think we've seen dynamic growth. There's a reason why Charles County is the fastest growing county in the state of Maryland.
Yeah, Delegate, I get your point. I think in this case, because this bill only applies to the university system, and the university system, as you know, the campuses are, kind of already geographically, in one place, right? We can't move the campus, right? So I get the argument. I might disagree with them, but I hear what you're saying about other types of projects where we'd apply prevailing wage. But in this case, I would think that, it wouldn't be as much of a concern because, College Park or Morgan State.
It's university systems overall. Right. So it's not, we're not putting Prince George Community College versus College of Southern Maryland.
Right.
Okay. Delegate Walker, thank you. I would remind you guys that Charles County is an amazing county. So that might be part of the reason these people ask that question. We have no further
Nobody
questions.
said that. That's speculative. That's speculative.
But thank you very much. I think all that, Delegate Lukey, thank you for your time. And I guess we'll move on. It's going to be, I don't see Delegate Smith. I know she has a small bill, but I think she's still busy. So,
I'm here.
oh, there you are. And Attorney General, just give me a few more moments where she has a very small bill.
No problem at all, Mr. Chair.
Okay, we're
Mr.
moving
Chair,
on.
may I go ahead?
Yes, Delegate Smith, go ahead.
Thank you so much, Mr. Chair and Vice Chair Crosby and members of the Economic Matters Committee. I'm here requesting your support for House Bill 448. It is a small bill, but it might be tiny and mighty to those that are impacted positively by its eventual passage. So last session, I had the good fortune of ECM actually favorably moving a bill very similar related to barbers and allowing those master barbers to take on not just one apprentice, but 3. Here I'm asking for the cosmetologists who felt a bit left out of my prior effort. They would like a similar assistance for those that are taking the apprenticeship track to becoming cosmetologists. So an experienced cosmetologist would be allowed to take not just one cosmetology apprentice, but 2. As you can imagine, the fact that there's some chemical treatments and other more complex things offered than traditional barbering, we thought that 3 would be too many for an experienced cosmetologist to take on, but we knew that 2 could be a true enhancement for those that are trying this endeavor, that pathway to actually getting their licensure. We have support from trade groups like the Professional Beauty Association and others who say this is a valid pathway. It does not supplant those who take the school route, but it provides another pathway forward. So I do hope that ECM will be favorable in the report on House Bill 448 as we help cut through some red tape and empower people who have skills to be properly licensed to work on our neighbors' hair. And with that, that's the end of my presentation. And I think we only have a few more folks that will be providing testimony in support. Thank you so much, Mr. Chair.
Thank you very much, Delegate Smith, for your concise dissertation. The first one will be, witness will be Rachel Allen.
Okay, hello, my name is Rachel Allen. I'm actually a little under the weather, so I'm not going to turn my camera on. But I would like to, first of all, thank you, Delegate Smith, for bringing this forward for us. And as a cosmetologist of 35 years, cosmetology teacher, 32 years here in Prince George's County, and a business owner who would have apprentice, I really would like to see an apprentice sponsor able to take 2 persons. As a classroom teacher with the ability to take and teach up to 25 students, certainly a sponsor would be able to handle 2 and oversee them, because as we know, an apprenticeship is an on-the-job type training. So that person already has some type of skill and they really just need a mentor, if you will. So I would really like to see us be able to serve 2 persons as an apprentice sponsor as opposed to 1, and that would remove barriers from persons who actually just don't have the funding to attend a traditional school setting. So with that said, I would like to see this particular bill passed and give that sponsor an opportunity to have at least 2 apprentices. Thank you.
Thank you very much, ma'am. Seeing no questions, we'll move on to our final witness to this bill, Ms. Shirley Leach. Is there a Ms. Shirley Leach event?
Mr. Chair, I believe she had a medical emergency with a close family member, so she did submit something in writing. I apologize, she couldn't be here.
Yeah, hope the best for her. That does then conclude the hearing for this bill. We now get to our final hearing of the day, and that's House Bill 299. We have the Attorney General here to present.
Thank you very much, Mr. Chairman. Members, good afternoon. Mr. Chairman, I don't think I've had the opportunity to congratulate you in person since you've been elevated to this exalted position. So congratulations. Nice to see you. Nice to see everybody else. The bill that we're talking about today, House Bill 299, is about wage theft. And it's a widespread problem in Maryland. And it's due in part because of the increased use of outsourcing in the workplace. Companies that at one time would have hired employees directly. Instead, insert an intermediary between themselves and their workers, and often these intermediaries are staffing agencies or contractors, sometimes subcontractors, are undercapitalized and take advantage of the employees. And they're vulnerable, the employees are vulnerable to wage theft, and they get cheated on overtime, they get cheated on their regular wages, minimum wage, sometimes on back wages that are owed at termination. And we have sponsor amendments to this bill that simplify it dramatically. And I apologize that we didn't come up with this idea in the beginning. I think we got it from the chamber. They said what we're trying to do is harmonize the definitions of employer in two Maryland statutes, the Maryland Wage and Hour Law and the Maryland Wage Payment and Collection Law. Our first take had it just change the definition of the title. It affects a lot of other situations that we didn't really intend to affect. So the amendments make it a much shorter bill and make it much simpler. The definition of employer in the Maryland Wage and Hour Law, along with many others, defines employers to include a person who acts directly or indirectly in the interest of another employer with an employee. And the Maryland Wage Payment and Collection Law has a slightly different interpretation. Maryland courts have held we're using the same definition of employer for both, the same tests for both, to see if one of these intermediaries who has failed to pay back wages is whether the true employer, the general, the overall employer, is going to be responsible when one of these consultants or intermediaries fails to pay the employees. The Court of Special Appeals has made clear that you apply the same test for both the Wage and Hour Law and the Wage Payment and Collection Law, but there are a number of federal court decisions that have interpreted our law differently. So what we're trying to do here is to write a law that's so simple that even a federal judge can understand it. And what we want to do is make sure, I'll give you two examples and then I'll be quiet and ask for questions, but I just want to give you two examples of federal cases in which employees have been denied protection under the Wage Payment and Collection Law. And one of them is a situation where the employees were hired by a subcontractor of Verizon. Their job was to install fiber optic cables. Their daily work involved digging trenches, installing piping, filling trenches, etc. They were working 12 to 16 hours per day, 5 or 6 days per week, and their wages were stolen. Their paychecks were withheld for their first week of work. They were only paid for 10 hours of work per day, even though they worked more, and they never, ever earned overtime. Taxes were withheld from their paychecks, but never remitted to the government. And Verizon trained these employees. They issued photo ID cards to the employees. Verizon supervisors were present for their work. They issued orders, what the employees were supposed to do. But the federal court found that the Maryland Wage Protection and Collection Law, the Payment and Collection Law, did not apply to these employees, and therefore they lost some of the wages that they were entitled to. Similar case, another one called Jennings versus Rapid Response. Rapid Response was a corporation that supposedly provided delivery and courier services, but they worked exclusively, the employees worked exclusively for Maryland Tire, a tire delivery company. Maryland Tire set their hours, set their wages. They had functional firing authority, and the employees weren't paid for any overtime despite working over 40 hours per week, weren't provided breaks during long shifts, arbitrary fees were deducted from their paychecks. And the court said, sorry, the Maryland Tire, the one who's getting the benefit of these services, is not responsible when Rapid Response said, we're not paying you, and ultimately was judgment proof. So it's those kinds of situations that we're trying to address. And we think if we make the definition the same for both acts, the federal courts will figure it out and start applying the law the way it should be applied. So I'd be happy to answer questions if there are any, Mr. Chairman, and I appreciate your time.
Thank you, Mr. Attorney General. Do you have any representatives that are going to be on from your beside yourself?
I know there are some folks who intend to testify in favor of it. No one else from my office is testifying.
That's fine. Well, I think I believe Delegate Ahrens has a question. Steve.
Thank you, Mr. Chair. Welcome, Brian. Good to see you.
Good.
I'm sorry, Mr. Attorney General.
Brian, please.
Brian, sorry about that. You mentioned Verizon. How many of these do we run into a year? How many complaints do you get a year on something like this?
I don't know. These are federal cases that we're talking about. So we don't see them generally.
Okay, so we don't have any real data to say that this is a widespread problem. It might be a one-off, two-off type problem we're trying to address here.
I don't think so. There's a line of federal cases, and if there are 5 or 6 cases, it means that there are probably a bunch of others that where people were victimized. But I mean, look, if you're making $12 an hour and somebody's cheating you out of 2, you're not going to be able to go out and hire your own attorney. And so a lot of these folks are stopped right at the point where the employer says, I'm sorry, I don't have the money, I'm not paying you. So the fact that there aren't, a zillion federal cases, and there are a bunch, but the fact that there aren't a zillion cases doesn't mean this is a small problem. And I think the folks that follow me can tell you how widespread it is.
Okay, I'll wait to get some more information. Thank you, sir.
Thank you, Steve.
Seeing no other questions, thank you, Mr. Attorney General, for your time. Thank you for being patient as well. We now have David Rodwin, Public Justice.
Yes, thank you. Good afternoon, Mr. Chairman, Mr. Vice Chair, members of the committee. My name is David Rodwin, and I'm an attorney at the Public Justice Center in our Workplace Justice Project, which aims to ensure that working people in Maryland are paid what they've earned and receive other basic job protections. We support HB 299 and the sponsor amendments. As the Attorney General described, wage theft of underpaid, low-wage workers is a major problem. In Maryland alone, and this goes a bit to the scope of the problem, a recent study estimated minimum wage violations deprive 580,000 Maryland workers of $875 million in wages each year, almost $1 billion just in minimum wage violations each year. In our experience at the PJC, wage theft is especially common when companies outsource labor through staffing agencies and subcontractors. I'll give just one quick example of such a case, very consistent with the cases that the Attorney General was describing. A large transportation company subcontracts with a smaller one. The drivers work 12-hour days, but are paid between $3 and $4 an hour, despite working 60 or more hours a week. The larger company trains the workers, tells them where to go, tracks their hours, is their employer in every way, but isn't the one signing the checks. The smaller subcontractor does that. When the workers sue for unpaid wages, the smaller company folds and the owner goes underground. Under the wage payment and collection law, as some of these federal courts are interpreting it, these workers are denied justice. This is a modest bill that really provides just a technical fix that would ensure that the same law is applied the same way in state and federal courts. It applies a standard that already exists in 7 other laws in Title III of Maryland's Labor and Employment Article, and which state courts already apply to the wage payment and collection law. We urge a favorable report. Thanks very much.
If there are no questions, I have a question, David. And I guess because I used to be a network engineer and I was always negotiating my own contract. I was a 1099 employee. Depending on the nature of the job, and many individuals will defer to the fringe benefits in order for a higher wage. How would this bill affect that?
This bill has no impact on whether a worker is considered an employee or independent contractor. So if a worker is a true independent contractor, they're not covered by the wage laws, whether it's the wage payment and collection law or the wage and hour law or any other in Maryland's labor and employment article. So in a case like that, if you were an independent contractor in those situations, it actually wouldn't apply here.
Well, and I guess that's my confusion because I'm an attorney as well, so I'm a little familiar with the law. That's how these people that you're alleging these thefts occur, because they do define them as independent contractors and not employees. So it doesn't sound like that's exactly what you meant to say when you said these aren't independent contractors, because they are by definition, which is why they're not considered employees, correct?
Well, under the law, so there's sort of two relevant tests here. This bill would apply solely to the joint employment test. There's also an independent contractor test, which looks at the economic realities, they call it, of the relationship between the worker and the putative employer. So courts, they do this sort of fact-specific analysis that looks at all the ways that the employer has the authority to exercise control, whether the worker is economically dependent on the employer. And so in that case, if there's a case, for example, where a worker, even though the employer said they were an independent contractor, the court looks at the situation, looks at all the different facts of the case, says, well, really, this worker's really an employee. And they were just being, maybe they got a 1099, maybe there was an independent contractor stamp put on their pay stub, but really this was an employee. And in that case, the worker would be an employee under the wage payment and collection law and the wage and hour law, and would be able to claim its protections.
And I guess I'm just worried, and I will definitely have to discuss this further with my counsels as well, because, contracts that have already been negotiated, I want to make sure that we don't interfere with those contracts by changing the nature of that relationship that was already negotiated out in contract. Again, I'm familiar with this from both a legal perspective as an attorney, as well as, my prior employment. So that was one of my concerns, but I will address that at a later date. We'll let the first hand I saw was Delegate Brooks.
Thanks, Mr. Chair. Yeah, David, is it what we have here are some bad actors? Because I think there are laws on the books right now that would seem like it would address a lot of these things. Now, I mean, especially under common law, I think IRS has got about 14 different categories that you got to go through to make a determination whether or not that particular individual is an employee or an independent contract. And on the withholding part, if you are withholding federal income taxes and that portion of the Social Security and Medicare, now you're violating a trust component, and then they come after you real hard on that. So I'm just trying to, and the other question too is, if a person is working more than 8 hours a day, is that overtime calculated on a daily basis, or is it calculated on a weekly basis? Yeah. So if if you could answer those particular questions, I'd appreciate it.
Thank you, Delegate. On the first question, the IRS does have its own test, which is a different test than the Maryland wage laws have. And that's because the purpose of the tax code is different than the purpose of the wage laws. Of course, the purpose of the tax code is just to make sure that the government is able to fund itself and its programs. And the purpose of the wage laws is to ensure that workers earn enough to live. Courts call them humanitarian statutes, remedial statutes. And so the wage laws are more protective of workers and more likely to find that workers are employees. There's a lot of confusion about that, both among workers and employers. But that's the sort of background there. But I also just want to emphasize again, this bill has nothing to do with what workers are independent contractors or employees. It's not connected to employment classification. It's just about when there might be a so-called joint employment relationship, when you have a general contractor that's really calling the shots here and is the employer in every way except is not the one signing the checks, that sometimes, I just want to be blunt, sometimes intentionally contracts with a sort of fly-by-night subcontractor, not always, but we see it many times, that might underbid a contract, and the general sort of got blinders on as to what's really going on, and is keeping those blinders there to sort of maintain plausible deniability by not signing the checks, but they really know these workers are being underpaid. If not for the interpretation that this bill would amend, workers aren't going to see justice in every case. As to your sort of second question about overtime, under state law, overtime is and federal law, overtime is calculated on a weekly basis. So only when you hit more than 40 hours in a work week. There are some local ordinances, and then you might have a employment contract, I guess, potentially, but I know Baltimore City's living wage ordinance requires payment of overtime after 8 hours in a day of work. But generally speaking, under Maryland law, it's 40 hours in a week. And I just wanted to note also, I know we have, and I'm very happy to answer more questions, but I know we have at least one other person going to offer testimony in support of the bill, Laura Patton.
Next question we have is Delegate Queen.
Thank you, Mr. Chairman. Dave, I was just trying to get a sense of, I thought I kind of understood this bill of some of the work I used to do before, and I needed to know what the rules were in our neighboring jurisdictions. So is this consistent with what DC and Virginia does, or are we different from our neighboring states as well in the way we handle this?
Maryland is a little bit different. It's a little weird, frankly, that in one wage law that Maryland doesn't have this definition of employer, and in 7 other laws in the labor and employment article it does. I don't think it makes a ton of sense. It's created this confusion in the courts. It's led to unnecessary litigation. It's led to a sort of situation where state courts are applying it one way and some federal judges are applying it another way. Other federal judges are deferring to the Court of Special Appeals and saying, well, Maryland has spoken on this, so what are we doing here? So Maryland is a little off in that sense, I think. And, I think Ms. Patton from National Employment Law Project might be able to speak a little bit more about sort of national best practices in that sense. But I think your instinct is correct, Delegate, that it is a little funny and confusing that the one wage law has the definition and the others don't.
Okay, thank you.
I believe that's all the questions we have for now. And I believe we have another witness, Laura Patton.
Hi, yes, thank you for the opportunity to testify. My name's Laura Padine. I'm with the National Employment Law Project. We're a national nonprofit organization that advocates to build a just and inclusive economy where all workers have good jobs. I'm testifying in support of HB 299 because it follows national best practices to promote uniformity and clarity in Maryland's wage payment and collection law. And just to be clear, HB 299 doesn't create a new test or standard. Rather, it conforms to the Fair Labor Standards Act standard that Maryland courts already apply, and that has existed for more than 70 years. The Fair Labor Standards Act contemplates that more than one employer can and should be held responsible for its provisions when a company decides to outsource all or a portion of its workforce to subcontractors like temporary staffing agencies. FLSA's joint employment standard is a practical one that looks at the economic realities of the situation, and Maryland courts have applied this standard under the MWPCL for a long time. Accordingly, HB 299 does not expand liability or create a test employers are unfamiliar with. It simply ensures all courts apply the MWPCL in the same way. As the Attorney General mentioned, that the clarity and accountability HB 299 would bring is important because outsourced work is so pervasive in our economy today. In many fast-growing industries, warehousing and logistics, janitorial, hospitality, manufacturing, to name a few, outsourcing has become deeply entrenched, and the number of workers employed by temporary staffing agencies is on the rise. Workers in these positions generally face lower wages, fewer benefits, more hazardous work, and less job security. By inserting temporary staffing agencies and other subcontractors between themselves and workers, contracting companies can degrade work conditions and more successfully avoid liability for violations of workplace laws, even as they benefit from and have the right to control the work itself. Maryland laws really must ensure that outsourcing employers are not incentivized to contract away their legal duties and immunize themselves from responsibility for workplace conditions they create. For these reasons, NELP supports HB 299. Thank you.
Thank you. I do have a question.
Sure.
So I'm trying to clarify, because it sounds like we're going two different directions here, because one of them says that basically we're trying to expand the employer to include individuals who they themselves did not contract with directly. But in doing so, are we also not just changing the definition of employer, period? Because the question remains, if there's an individual who does not pay state tax, he does not pay federal tax, he does not get FICA withdrawn, he receives a straight amount, the same amount of money every 2 weeks, then that's part of the test in determining whether he is an employer or an employee. So under this new definition, would that change him going from being a employee to employer? I'm saying employee to a subcontractor. Do you understand my question?
I'm not sure if I understand it, but let me see if I can approach it this way. So this bill is talking about folks who are already classified as W-2 employees.
It does not address 1099. If this was not
No.
And that
no,
was
this is talking about W-2 employees who are the direct employees of a subcontractor, quintessentially a temporary staffing agency, right? So they're already employees. The question is there a second entity that's also responsible as an employer? And as Mr. Rodwin was saying, right, what we see is in many cases, companies will contract out work to these labor intermediaries, temporary staffing agencies. Many times they're thinly capitalized, they don't have a lot of resources. So if they break the law and they commit wage theft, those workers may not be able to get full recompense from the direct employer. So the question is, when and to what extent are the companies that are outsourcing work to those labor intermediaries, when should they be responsible as a joint employer? This is adopting the clear, straightforward standard used by the FLSA, the Fair Labor Standards Act, federal standard, and saying that oftentimes those contracting out agencies, a contracting out company should be jointly responsible as employers when they can control the working conditions and when they benefit from the working conditions. There's a test already in place, right? So this is just clarifying it, but it doesn't apply to independent contractors. So.
That's why I heard us beat around that bush, but I wanted to be made specific that we're not talking about 1099 employees. We are just talking about individuals. Now, lastly, under this new definition, can the state in fact be held accountable for the work of a subcontractor? Can we be sued because a subcontractor or even a general?
Now, I'm not. So you're saying that if the state subcontracts work to a
we contract work all the time. That's correct.
I believe it does apply to any employer, so government employers as well, potentially, but I'm going to double check on that.
I just noticed on the fiscal note, they didn't seem to talk about that. However, to my knowledge, after reading it, it does seem like it would affect and could affect the state. The actions of a subcontractor could affect the state if we hire a general that actually does business with these nefarious subcontractors. It does look like it could affect the state.
So I think that's a bit of a different situation. So if you're talking about when the state of Maryland contracts out work to a general contractor, and that general contractor then hires subcontractors, what this would most likely affect is whether the general contractor is liable for the
Very
subcontractor,
well
not
worded.
whether the state of Maryland is, because then in that instance, the state of Maryland isn't controlling the conditions in any way. So in that instance, it would be holding the general contractor.
We
jointly
did
responsible
change
for
that law
subcontractors.
though, to make it where they can skip over somebody that they have not in fact contracted with the super. That's fine. We'll make sure we get to the bottom of that. Delegate Queen, do you have a question? I noticed your hand was up, but you're not on the screen. Hearing none. Delegate, oh, did you have one? Okay. We'll go to the next witness, Mike O'Halloran. Yeah, we'll go to Mike O'Halloran.
Yeah, good afternoon, Mr. Chairman. Thank you very much. For the record, Mike O'Halloran here on behalf of NFIB in opposition to House Bill 299. Look, even with the sponsor's amendment, it would seem the bill is pretty straightforward, at least from an aesthetic standpoint. It certainly shortens the bill. But as you've seen today, it presents and creates a complicated situation that NFIB is concerned will make it harder for small businesses, particularly those in a franchise agreement. If 299 passes, our worry is the cost for those licenses, between the franchisor and the franchisee, the cost for those licenses goes through the roof. And why? It's pretty simple, because the franchisor would have increased liability. They need to account for that. That costs money. That means the small business owner who operates a Chick-fil-A, a Subway, a Holiday Inn, they will have to pay that much more for the privilege to operate. So the would-be entrepreneur that wants to open up that restaurant or that hotel is now looking at higher licensing fees. In the end, that means less jobs, less of your constituents getting hired, and higher licensing fees and less economic opportunity. Our members believe that an honest day's work deserves an honest day's pay. We do not defend, the actions of unscrupulous employers, these fly-by-night operators. Instead, we want to ensure the small business owners that are playing by the rules, that are paying their employees, are not faced with higher costs of doing business. For these reasons, we request an unfavorable report and appreciate the committee's time.
Seeing no questions. Move on to Ellen Valentino.
Thank you and good afternoon, Mr. Chairman. My name is Ellen Valentino. I'm here today representing the Mid-Atlantic Petroleum Distributors, and I will be submitting an amendment to the committee for consideration. And I know I missed the deadline. I'll be emailing it out to the members as well. I do, and my members have concerns about this possible joint employer test, specifically as it relates to service station dealer suppliers and distributors. The issue becomes when and if there is a default by a service station dealer, can the supplier or distributor be considered a joint employer? The same thing holds true between a franchisee, franchisor. These are not circumstances that I think the Attorney General laid out where his instances that he brought forward needed to be addressed. But very specifically, I do think this raises an issue when you have two parties that have contractual agreement, a franchisor to create an entrepreneur, a small business owner. The issue becomes, we think we need a bright line of responsibility to that employer, that franchisee. And again, I will submit this as well. Again, an example would be a supplier of gasoline who is the landlord of a service station property of a facility and also has a supply agreement with an independent small business owner, that service station dealer. So I hope you take this into consideration. And I think that it would be the proper thing to do if you move forward to have a clear, bright line for this organization. Thank you.
Any questions? Seeing no questions, we have Chan McCult next.
Thank you, Mr. Chairman. Appreciate your time, the time of the committee. At the outset, let me make clear that the General Assembly has already spoken with respect to construction services. And despite our efforts to amend what you all have done, general contractors are responsible for anything a subcontractor does in terms of violating the wage and hour law, the wage payment and collection law. So to that extent on a construction project, we're already dealt with. Obviously, we have subcontractors not on construction projects. I think the Attorney General is missing a great opportunity to make the law in Maryland crystal clear and to remove ambiguities about whether or not there's a employer type relationship between a general and a subcontractor, whether it's a hiring agency or not. And the place to look is the National Labor Relations Board's joint employment rule. I've submitted written testimony. I'm not going to regurgitate that for the committees out of respect for their time. But the critical thing is that there's a joint employer status only when essential terms and conditions of employment are dictated by the general contractor to the sub. Then the general contractor is responsible for wage payment issues of that subcontractor's employees. But Maryland law uses, frankly, vague and what I've termed squishy language, direct or indirect control. That's capable of definition many different ways. And I think the Attorney General has seen that in federal cases. We would urge an unfavorable report.
Thank you, Champ. Seeing no questions, I believe that's all the testimony we have on this bill. I wanted to ask the Attorney General one more thing, sir. If you could, I don't know if you heard my question or not, because the way I read this bill, this would and could make the state liable for lawsuits. And I just wanted to have somebody from your office reach out to me at any time, because it does seem like by definition we would be.
Yeah, Mr. Chairman, I don't think we would. I mean, we're talking about essentially the joint employer rule. It's where, you have an intermediary and you have a general. The general is controlling the work, but the intermediary is writing the checks. And when the employees get stiffed and the intermediary disappears, it applies to the general. And the state doesn't do that. It's when we build when we build a highway, when we build a bridge, we hire a general contractor. And the general contractor, depending on how involved the general contractor is with the work of the subsidiary, if it's hiring and firing the employees, as in a couple of the cases I mentioned was the case, if it's setting their wages, if it's telling them when to work and what to do, then it may be liable as a joint employer. But that doesn't mean that the person who hired the general contractor would be liable. And that's the role. We hire the general contractor, the buck stops at the general contractor.
Okay, because I know when we wrote the bill for construction, because this isn't just construction, this is everyone. We did allow them to skip 1, 2, if not 3, to find a viable source, meaning if you do business with, if you get the whole thing, if you lay down dogs, you're gonna get fleas. That was kind of the theory behind that one, that if we hire somebody, that would include the state, depending on, again, if the GC disappears, the state would then be responsible. So again, it's not, we don't have to go back and forth, because it doesn't really change the nature of what you're trying to do. And honestly, we should live by the laws we create anyway.
Right.
So this wasn't to be said as in the pejorative. It was more factual than anything.
Understood.
I do see we have a few questions. I ask you guys to stay on. Delegate Queen, I think this is for Champ McCullough.
Yeah, I did have a question for him regarding the definition that the state uses for the joint employer. So I guess my question is, how does that compare to our neighboring states? Is that what we need to change here? Because you said we're missing a great opportunity. I'm trying to figure out, how do we fix this then?
Delegate, I appreciate your question, and I wish I had an answer for it. I did not look to see what DC or Virginia law was, but I'd be happy to do so and get back to you.
Thank you very much, sir. And I just want to remind everyone that the chats and the hand raises are really only for the delegates. Chris Adams, no, you have a question?
Thank you. And I wanted to ask the Attorney General, because I got to be honest with you, I had the camera off for a minute or two. So if it's already been asked, just stop me. But with franchises. So these relationships between franchisor, franchisee. How do you expect a law like this, were to pass, relate to those sort of business models? I assume McDonald's is an example. And you know what, I almost never use businesses by name, and I should retract that, but it gives you the example I'm talking about.
You're fine.
Thank you, Delegate. It's a good question. I don't think this is going to apply to franchise agreements, certainly not broadly. There may be some situations in which the franchisor says, okay, I'm going to hire the following 5 people who are going to work for you. I'm going to set their wages. I'm going to be there in the store, in the restaurant or whatever, and I'm going to tell them, I want you to wash that dish. I want you to wait on that customer. It's only in those situations where there's a joint employer situation. Most franchisors are very careful to make sure that they don't get involved at that level of their franchisees' businesses. And the reason is they don't want to be they want to get their franchise fees and be done with it. You know, you cook the French fries, you cook the hamburgers, pay me the money. And so I think franchises is the last place that I would expect to see this happen. There will certainly be some exception to that. There'll certainly be some franchisor who says, I'm telling you guys what to do.
And Chris, you know, I get yelled at by my counsel a lot, but this is something you'll have a chance to work through in subcommittee. I know this is so any other questions you had, not to cut anybody short, but we'll definitely have some work to do on this one.
No, Mr. Chairman, I had a very focused question on franchises.
Thank you very much. And I believe that ends the hearings for today. Colleagues, please don't jump off just yet. We have a 3 o'clock voting session. Again, 3 o'clock voting session. I expect to see all your smiling faces for all the witnesses. Mr. Attorney General, thank you guys very much for logging on. I'll see y'all at 3.
Thanks a lot, Mr. Chair.
Thank you, sir.